So welcome everybody to the HR Huddle. For those that don't know, I'm Eloise Shelton of Vanilla Recruitment and founder of the HR Huddle. We specialise in recruiting HR, marketing, office and accountancy roles. Our speaker today is the wonderful Keeley Baigent of KSAB Law. Today, she's going to update us on the latest developments in employment law and the progress on the Employment Rights Bill, and she's going to talk about AI in the workplace. So today's session will last approximately an hour and is going to be recorded. If anybody has any questions, feel free to unmute yourself to ask a question or pop it in the chat box and I'll ask questions on your behalf as we go through. There'll also be time for questions at the end of the session. Now, we do have a lot to get through today. So we're going to start with the case law and the rights bill. And then we're going to go on to AI. So if you need to leave, please don't worry. The session will be recorded and I'll send it out to you next week. But I will pass over to Keeley and thank you for joining us.
Great, thanks Eloise, and hello everyone. As Eloise has said, there's always so much to cover in these updates. So I'm going to share my screen now and put on the slides. So, progress then of the Employment Rights Bill. As we know, it was introduced into Parliament on the 10th of October 2024, and it sets out 28 employment law reforms. Over 200 amendments were proposed throughout the ERB committee stage, which ended on the 16th of January of this year. All the government amendments that were proposed were approved, including significant ones. In March, the Employment Rights Bill passed through the Commons report stage and third reading. The bill had its first reading in the House of Lords on the 14th of March of this year, and as the bill will fulfil a general election manifesto, the Salisbury's Convention dictates that the House of Lords will not try to vote it down, but it will be amended potentially as it goes through. The second reading took place on the 27th of March, and the committee stage in the House of Lords started on the 29th of April. The commencement provisions in the bill confirm that powers for the Secretary of State to make regulations under the bill will come into force on the day it receives royal assent. The detail on many of the policies contained in the bill will be provided through those regulations and in some cases codes of practice after the bill has received royal assent. The government has stated that it's committed to ensuring that all stakeholders receive appropriate time to prepare for the changes ahead of their commencement. It will consult on measures, it says. There were 4 consultations published last year. They've now been dealt with, and there are more consultations due this year. So let's have a look then at what was published in March alongside the original document. There were some notable rights that were actually included in the original bill that had been removed. And these included the introduction of the new right to disconnect or the right to switch off, if you remember. It appears, therefore, that this right has been dropped. There's been no confirmation of that, but as it doesn't appear in the last draft, it's perceived to be now removed. As I said, I'm mindful that we covered a lot of the progress of the bill in March. So as I say, I'm going to focus on what's being pursued and in particular the pertinent points and the pertinent matters in the bill. So starting then with the hire and fire changes. Under the bill, it will be automatically unfair to dismiss an employee when the reason or the principal reason for the dismissal is either the employer sought to vary the employee's contract of employment and the employee did not agree to the variation, or to enable the employer to employ another person or to re-engage the employee under a varied contract of employment to carry out the same duties or substantially the same duties as the employee carried out before being dismissed. So in effect, replacing the employee in a different type of role. An exception will be made where the employer can show, firstly, financial difficulties that are affecting or are likely to affect the employer's business and which the changes would eliminate, prevent, significantly reduce or significantly mitigate. And secondly, the need to make the changes in contractual terms could not reasonably be avoided. So due to the wording that's underlined there, it's going to be quite important for employers to provide documentation and evidence that the changes are needed for financial reasons. It's going to be essential. It is a significant shift, therefore, in the current regime of how the tribunal works, where it doesn't usually want to consider any financial reasons put forward by an employer, and it usually takes them as read. But because of that wording, it's going to be essential for an employer to actually disclose the financial need and its evidence in support of that to the employment tribunal. There will be no minimum qualifying period of service to bring a claim of automatically unfair dismissal on this ground. So this is going to be potentially a big shift in trying to change employees' terms and conditions of employment. What about 0 hours workers? So this again is received quite a big amount of publicity since the Employment Rights Bill was published last year. The provisions relating to 0 hours and low hours contracts, which were announced, now extend to agency workers, and they have done from the amendment since the time that the amendments were made in March. The provisions in the bill have really attracted so much criticism because of the complexity and the burden that they're going to potentially place on employers. The provisions don't fulfill explicitly the banning of 0 hours contracts, but they may certainly reduce the use of these types of contracts because of the administrative burden that the legislation is potentially imposing on employers, and also the fact that generally the practice of 0 hours contracts is going to reduce. So employers may decide to start auditing their workforces ahead of the reforms taking effect to identify which workers that they engage on 0 hours and minimum hours contracts it's going to potentially affect. They may also decide to identify seasonal fluctuations in demand for work to identify where fixed term contracts may be more appropriate. But if employers are going to look at using fixed term contracts and transfer 0 hours onto fixed term contracts, then they have to be reasonable. They have to be reasonably used. Employers should also review their current systems for managing shifts and shift changes. They may need to consider implementing more sophisticated or efficient systems to manage shifts ahead of the reforms. So what are the new rights? Well, the bill introduces a duty on employers to offer a guaranteed hours contract that reflects the hours that the qualifying workers and qualifying agency workers have regularly worked over a reference period. Now, the reference period isn't stated in the bill, but it's thought it's going to be 12 weeks. An employer will be required to make a guaranteed hours offer after the end of every reference period. So if an employee fails to accept the offer of the permanent contract that's been offered at the end of the first reference period. Then another reference period starts, and the employer will then have to offer again a permanent contract at the end of that reference period. And the obligation is on the employer to do that. So it is going to create potentially an administrative burden on the employer to keep doing it. It will mean, therefore, that the offer will have to keep being made until the worker or the agency worker no longer satisfies the definition of a qualifying worker, which will be when they're no longer considered to be working under a 0 hours contract or a low hours contract, or when they accept the permanent contract offer. With regards to agency workers, it will be the responsibility of the hirer rather than the work-finding agency to make a guaranteed hours offer to a qualifying agency worker. A guaranteed offer cannot be for a fixed term, as I've said, unless it is reasonable. So what's meant then by a qualifying worker and a qualifying agency worker? It's detailed in the legislation, and in the main, this involves them working a set number of hours and at a stated regularity during the reference period. Now, the number of the hours and the regularity is going to be something detailed in regulation. So at the moment, we don't even know what it is. Some particular workers will be excluded, and this might be firefighters or seasonal workers. There's going to be consultation about what will constitute the qualifying low hours contract. And there are some exceptions to the duty to make a guaranteed hours offer, example, where there is a termination of the worker's contract. The worker will be able to give notice that they accept or reject the offer, so they can choose to remain on their existing 0 hours, low hours or agency worker contract if they wish to do so. But if they do, the employer's obligation doesn't cease, and therefore when the employees worked or the workers worked another reference period of the 12 weeks, then the employer will still have to make that offer again. So there will also be a requirement for employers to take reasonable steps to ensure that workers are given specified information in relation to their rights to guaranteed hours during an initial information period. So again, the obligation is on the employer to make sure that it informs its workers of this right that they have to be offered a permanent contract. The detail of the information to be provided in this initial information document is going to be confirmed in regulations again. The information period will be 2 weeks from either the first day of the worker's employment or when the worker becomes a qualifying worker or when the legislation comes into effect, whichever is applicable in the circumstances. So what if you don't make this offer? Well, complaints can be made to the employment tribunal. A worker will be able to bring a tribunal claim if their employer fails to comply with the duty to make a guaranteed offer, hours offer. They can also make a claim if the offer doesn't comply with the requirements of a guaranteed hours offer. And they can make a claim if the employer fails to comply with its duty to provide the information in the information period, in the 2-week information period. If the tribunal considers the claim well-founded, it will make a declaration and it will award compensation, which is determined to be just and equitable, subject to a cap, which is going to be determined by regulations. Prior to the government amendment to the bill proposed in March, it seemed possible that employers could try and avoid the duty to offer guaranteed hours by ensuring that the workers worked less than the threshold number of hours during the reference period. But an amendment that was made in March now scuppers that. And it makes it clear that a worker has a right to bring a claim in the employment tribunal if the employer has manipulated the hours to bring the hours below the threshold, with the intention, obviously, that the employer with the intention of the employer making a lower guaranteed hours offer is to avoid the obligation altogether. So it's a veto now, and people were saying, oh, we can get around it this way by ensuring that they work below the threshold. But as I say, if an employer is deemed to be doing that to avoid the obligation to make a guaranteed hours offer, then a tribunal claim can be brought by the worker for that. Also, there will be an obligation under the bill to benefit, for workers to benefit from the employer's duty to provide reasonable notice of shifts. So we've got the first obligation to make an offer, guaranteed hours offer. And then we've got the second obligation to ensure that we provide reasonable notice of shifts. So again, who does this apply to? It applies to workers who are employed on 0 hours contracts, low hours contracts, and or shift workers where the shifts are not contractually guaranteed. When the duty applies, the employer will have to give a worker reasonable notice of a shift, specifying the date, the start and end time, and the number of hours to be worked that the employer requests or requires the worker to work. The responsibility for the right to reasonable notice of shifts for agency workers will be shared by the work-finding agency and the end hirer. The duty to give reasonable notice of shifts will not apply where the worker suggests working a shift or a longer shift and the employer agrees. So if the employee makes the request, the obligation doesn't apply. It's when the employer is requesting the employee to work the shift. It has to be reasonable notice. When notice of a shift has been given and the worker has agreed to work the shift, the employer will then have to give reasonable notice to cancel the shift or make any changes to it. So that's another burden on the employer. So once the shift has been agreed, any changes, again, the employer must give reasonable notice of. What can the worker do if the obligation on the employer isn't met? They can bring a claim in the employment tribunal. And what can the claim, what will they be given if they succeed in the claim? They will get a declaration that the claim is well-founded, and they will be awarded compensation that is just and equitable in the circumstances to compensate the worker for any financial loss that's attributable to the unreasonable notice, again subject to a cap to be specified in regulations. So it might be that the claim is simply worth the value of the shift, that the employee is saying, because I haven't been given reasonable notice of this shift, then I should be compensated because I can't work it. So, I mean, we're probably looking at low-level compensation, but it's still the hassle and the burden generally on employers to defend these types of claims. Moving on then to trade unions, there have been a huge proposed changes to existing legislation relating to trade unions. Nearly all of the restrictions placed on industrial action and picketing are going to be removed. I'm not going to go through all these today, but there's two that I do want to mention. The first of these is the introduction of a legal duty for all employers to inform their employees about their right to trade union membership, even if the employer doesn't recognise a trade union. The bill will require employers to give workers a written statement advising that they have the right to join a trade union at the same time as providing the workers Section 1 statement, contract of employment, or at any other prescribed time set out in legislation. The second right I wish to mention is the introduction of the right for trade unions to access workplaces. In summary, these provisions will enable trade unions and employers to enter into what's called access agreements for union officials to access employers' workplaces for various purposes, but expressly not to organise industrial action. A brief mention then of the further changes in respect of sexual harassment law. From October last year, as we all know, employers had an obligation to take reasonable steps to prevent sexual harassment of their employees during the course of their employment. Where the duty is breached, tribunals can uplift the employee's discrimination compensation by up to 25%, and the Equality and Human Rights Commission has the power to investigate and take enforcement action. The bill will require employers to take all reasonable steps to prevent sexual harassment. Regulations may specify what is going to be regarded as all reasonable steps, but we shall see. The duty to take all reasonable steps to prevent sexual harassment of employees will be significant and definitely an onerous one for employers. It's going to be much more difficult and pretty impossible, I'd say, to successfully defend a sexual harassment claim. Concerns have been raised by the Employment Law Association that the all reasonable steps requirement will be so onerous that it risks imposing strict liability. It's really that onerous. So it's going to be, as I say, extremely difficult, if not impossible, for employers to defend sexual harassment claims. What also is interesting is the bill will introduce employer liability for third-party harassment in relation to all relevant protected characteristics. So under the bill, an employer will be liable if a third party harasses the employee in the course of their employment with the employer, and the employer failed to take all reasonable steps to prevent the third party from harassing the employee. Now, a third party will mean any person other than the employer or one of its employees. This is significant in the areas particularly of hospitality. How on earth are employers going to be able to stop their regular customers or even one-off customers from sexually harassing their staff? They will, if they can't, they will definitely be liable for that third party harassment, which seems potentially quite unfair for employers, because employers obviously have some control over what their employees do. They can make sure that they implement training and have the right policies and procedures in place. But what can they do to prevent sexual harassment from third-party customers? They will need policies. They will need to make sure that they are publicly displayed and accessible by clients and customers. But is that going to go far enough to prevent sexual harassment of their staff? The next change then that I want to refer to relates to dismissal during pregnancy or statutory family leave. So under the bill, protection against dismissal will be strengthened for pregnant women, those who have been pregnant and those taking or returning from a period of statutory family leave. So the bill permits regulations to be made about dismissal after a period of statutory leave, for example, maternity leave, adoption leave, shared parental leave, extended paternity in respect of bereaved parents, and neonatal leave. No context is given in the explanatory notes of the bill as to what regulations may be made under this power, save for statements about banning the dismissal of pregnant employees for 6 months after their return to work, except in specified circumstances, which may well be redundancy. The bill also introduces a number of what have been referred to as day one rights to family leave. So paternity leave will become, under the bill, a day one right for eligible employees. It currently requires 26 weeks service at the relevant date. Unpaid parental leave will also become a day one right for eligible employees, and it currently requires 1 year's service. With regards to bereavement leave, the existing right to 2 weeks parental bereavement leave following the death of a child under 18 or a stillbirth will be extended. And it will be extended to be an entitlement to a more general bereavement leave, which will apply to the loss of a wider group of persons. So like the current provision for parental bereavement leave in the more general sense it's going to be introduced will be a day one right. Regulations will specify the relationships with a person who has died that will qualify an employee to take the bereavement leave. And regulations will also ensure that where the person who has died is not a child, the minimum period of leave will be 1 week. As I say, current legislation provides that the minimum period of leave is 2 weeks where the person who has died is a child. Statutory parental bereavement pay will continue to be payable where a child has died, but there is no provision in the bill that the wider class of bereavement leave will be paid. So it will be a potentially an unpaid right. Saying that, the existing protections for those who have taken parental bereavement leave are extended to bereavement leave in the general sense, such as the right not to suffer a detriment for taking the leave or stating that they're going to take the leave. And if they're dismissed for taking the leave, then that dismissal will be automatically unfair. Given that the new entitlement will be unpaid, it'd be interesting to see if the right is taken up. Many people take sick leave if a relative dies, but as I say, they will be entitled to this unpaid minimum of a week's leave if they wish to proceed with that. But it will be unpaid. So whether they tag that onto or put it before a sick leave period, we'll see. There were recommendations put forward in March for an amendment to the bill to entitle eligible employees to 2 weeks bereavement leave and statutory bereavement pay in the event that they experience pregnancy loss before 24 weeks. This would include miscarriage, ectopic pregnancy, molar pregnancy, IVF, embryo transfer loss, and medical terminations. And some celebrities, you may recall some celebrities were involved in proposing that amendment. While the government didn't accept the proposed amendment, it accepted the principle of bereavement leave for pregnancy loss generally, and further discussions will take place with a view to the bill being amended during the passage during the passage in the House of Lords. So we'll see whether or not that is introduced during the House of Lords reading of the bill. In respect of flexible working, since the 6th of April last year, 2024, employees have had a day one right to make a request for flexible working. An employer can refuse that request for one of the 8 prescribed statutory reasons set out in the legislation. The wording of the legislation suggests that the test is a subjective one. So if the employer believes that one of the 8 grounds are satisfied, they can reject a flexible working request on that basis. They don't actually have to give reasons at the present time for rejecting the request. The amendment in the bill proposes a more objective test than a subjective one, which means that the employer is going to be required to put forward reasonable grounds to reject a flexible working request on one of the 8 permitted grounds. I'm not sure this is going to change things a great deal because most employers will reason their decision about rejecting an application, mainly to defend any potential sex discrimination claim that's made against them. So I'm not really sure it's going to have a huge consequence or really add to the workload of as present HR people or businesses generally in dealing with flexible working requests. We've all seen the publicity about SSP. So the bill confirms that statutory sick pay will be payable from the first sick day rather than from the 4th day, therefore removing the 3 waiting days. In addition, under the bill, there will no longer be a requirement for the employee's earnings to be not less than the lower earnings limit to be eligible for SSP. So SSP is currently paid at a prescribed weekly rate, but the bill will change the existing legislation so that the weekly rate of SSP will be the lower of the prescribed weekly rate and the prescribed percentage of the employee's normal weekly earnings. And that's likely to be 80%. So as a result of those changes to the SSP regime that are being proposed, again, employers are going to face an increased liability around SSP, in addition, obviously, to the increased employers' NI that came in April. I'm not going to go into any detail about the repeal of the 2 years qualifying period to bring a claim of unfair dismissal. We have heard about it, and I did talk to you about it in March. It isn't due to come into effect until October. I'll only say that you'll be able to dismiss fairly during the first year of employment, as long as you follow the modified dismissal procedure that we're all going to hear about at some point when the regulations are made. And as I say, you do it in the first year. So it's really a 9-month period. And then if you give an employee notice during that 9-month period, the 3 months notice falls outside of that. So we're looking at potentially a 12 months window. Looking and moving on then to tribunal time limits, the employment, so the bill, well, at the moment, the Employment Rights Act allows for 3 months to bring a claim of unfair dismissal and other claims. This is going to be extended to 6 months. So a longer window for employees to bring claims in the employment tribunal. And also, just to mention the last point, which is about working time records. Under the Employment Rights Bill, employers will need to keep adequate records to demonstrate compliance with all annual leave entitlements. So that's all those that are detailed in the working time regulations. So we will have an administrative burden on us now to ensure that those records detail our compliance with annual leave. If the new provisions are agreed and they come in, the records will need to be kept for 6 years in such manner and format as the employer reasonably thinks fit, and failure to do so will constitute an offence punishable by a fine. So making sure that we have that documentation in place. So that's my whistle-stop tour of the progress of the Employment Rights Bill. I'm going to move on then to the second section, which deals with some case law developments. And in particular, I'm going to talk to you about the well-publicised recent case of 4 Women Scotland and Scottish ministers. In this case, the Supreme Court considered whether the definitions of woman, man and sex in the Equality Act refer to biological sex, or whether the definition of woman or man includes trans women and trans men who hold a gender recognition certificate. So the background to the case then is that under the Gender Recognition Act, a trans person who is at least 18 years old can apply for legal recognition of their acquired gender through the issue of a gender recognition certificate, or a GRC. Once a full GRC has been issued, a person's gender then becomes, for all purposes, and that's detailed in the legislation, for all purposes, the acquired gender. However, it's stated in the Act that this is subject to any provision made by the Act itself or any other enactment or subordinate legislation. So looking then at the Equality Act, as you know, gender reassignment is a protected characteristic under that legislation, and sex is a separate protected characteristic. The protected characteristic of sex in the Equality Act is binary, only referring to a man or a woman. In April 2023, the Equality and Human Rights Commission recommended that the then Conservative government should consider redefining sex in the Equality Act to mean biological sex, to make it clear that it was biological sex that we were referring to and not acquired sex. It doesn't include acquired sex with a certificate. The Human Rights Commission, Equality and Human Rights Commission, considered, however, that the implications of that change would need to be considered carefully, and in particular in relation to any possible disadvantages to transgender people. So moving on then to the considerations of the case generally, there's a legislation in Scotland called the Gender Representation on Public Boards Act. It received royal assent back in 2018, and it requires positive action to be taken to redress gender imbalances on public sector boards in Scotland. It says the objective is that 50% of the non-executive members on the boards should be women. And women was defined in that act as including a person who had the protected characteristic of gender reassignment. So what that legislation was saying at that time was that the 50% prescription for women to sit on boards would also include those who have acquired the gender of women under a gender under a certificate, under a recognition certificate. So at that point, the For Women Scotland brought a case, and that was called For Women Scotland and Lord Advocate. And the Inner House of the Court of Session held that this definition impinged on the nature of the protected characteristic of sex under the Equality Act, and therefore went beyond the legislative competence of the Scottish Parliament, and the definition was declared to be of no legal effect. But despite this, in 2022, the Scottish Government published a revised statutory guidance, and this guidance indicated that the definition of a woman should include trans women. So hence the case began again. So for Women Scotland, they campaigned for strengthening the rights of women and children in Scotland. They brought judicial review proceedings against the Scottish ministers about the fact that the statutory guidance did not conform to the previous decision. They contended that the definition of woman in the Equality Act should be taken as a reference to a biological woman. Further, it argued that any attempt to conflate that concept with that of a person who has an acquired gender of female under a gender recognition certificate was impossible and impermissible, as well as defeating the purposes and undermining the policy of the Gender Representation on Board Act. Both the Outer House and the Inner House of the Court of Session ruled that the revised statutory guidance was not unlawful. So they agreed that the definition of sex should include transgender women. So the FWS appealed to the Supreme Court, and there were a lot of interested parties in that case. The decision then. The Supreme Court unanimously upheld the appeal. So they sided with the women's organisation. It stated that Parliament intended that the words man, woman and sex in the Equality Act refer to biological sex. Trans women holding a certificate were therefore excluded from the definition of women. The statutory guidance issued by the Scottish Government was incorrect. Trans women holding a certificate could not be included as women in the definition of women for the purposes of the Gender Representation on Public Boards Act. Now, the court made it clear that its decision was not to be viewed as a victory by the women's group. And it did clarify that it was aimed at, all the legislation is aimed at fairness. But of course, the women's organisation and the media bodies have very much published this decision as a victory for women and women's rights. It does have some significant implications on employers. And the first of these is that generally for lawyers, for HR people, and for businesses, it's now provided clarity on the meaning of man, woman and sex in the Equality Act. But employers will need to consider their policies and procedures to ensure that they now align with the judgment. Where an employer has a general occupational requirement for a person holding a role to be of a particular sex, they will now be lawfully able to exclude trans people with that acquired gender, even where they hold a certificate. Equally, where an employer takes positive action, measures aimed at supporting those of a particular sex, they will be able to lawfully exclude trans people holding a certificate. Employers must, of course, ensure that they treat transgender people fairly and equally, and of course they are still protected under the Equality Act as that is referred to as a protected characteristic. So in respect of transgender people, employees and service users who suffer discrimination or harassment on the basis of gender reassignment remain protected. they remain protected based on the protected characteristic of gender reassignment, but they also remain protected under the perceived notion detailed in the Equality Act, i.e., if someone's perceived to be of the opposite sex and they're discriminated against because of that perception, then they can bring a successful claim of disability, of sex discrimination. In respect of diversity data, it's important when gathering this that employers record biological sex rather than the certificated sex. So they'll need to have, or you'll need to have, two records, one relating to biological sex and an additional question as to whether the employee identifies with a sex other than their biological one. The one that has been publicised, though, that flows from this, or the implications of the case, is in respect of workplace toilets. So the workplace health, safety and welfare regulations require separate toilet facilities for men and women unless the toilet is an individual lockable unit or room with floor-to-ceiling walls and door, as opposed to cubicles. Similar provisions apply to changing rooms. So while the court in the For Women Scotland case did not directly address workplace toilets, it did refer to toilets in a service setting, and it follows that in the workplace context, the legal position is that trans women should not be permitted to use toilets designated exclusively for women. Some newer buildings have unisex toilets, don't they? And if they've got lockable units, and that's absolutely fine, it meets the requirements. But if they have buildings where they've got cubicles rather than individual units, then the employer is going to need to identify which facilities can be used by a transgender person and which facilities can be used by the single sex.
Keeley, does this work the other way around too for trans men?
Yes, it does. Yes, exactly the same. Yeah.
Lovely, thank you.
So following the Supreme Court's ruling, the Equality and Human Rights Commission have issued their interim guidance and made some changes to their previous guidance. And it stated that for workplaces and services open to the public, trans women should not be permitted to use women's facilities, and trans men should not be permitted to use men's facilities. However, the Commission has also emphasised that trans individuals should not be left without access to facilities. So I think generally service providers and employers are going to need to ensure that they have separate facilities for transgender individuals, and then make it clear that that is for that purpose, and then other facilities for men and other facilities for women. In response to the Supreme Court's ruling and the amendments to the Commission's code, Barclays has announced that it will prohibit trans women from using female bathrooms in its buildings. Barclays' chief executive stated that the decision is intended to ensure compliance with the law. It's one of the first companies to announce a change to its bathroom policy following the court's decision. Its approach has attracted much debate and raises questions about the impact on the LGBTQ community, as well as the community at large. Britain's first known transgender judge, Victoria MacLeod, has announced plans to take the UK to the European Court of Human Rights over the court's ruling, citing infringement of her Article 6 human rights. So we'll see where that goes. The Commission is working on an updated code of practice to provide guidance on implementing the court's decision, which is expected to be submitted to the government for approval by the end of this month. So an interesting and, a very interesting development, I think, there. So I'm just going to touch upon a development under whistleblowing legislation. I'm not going to go into the facts of this case, but I will tell you the principle. It's the case of Sullivan against the Isle of Wight Council. And the principle to take away from the case is, well, it's confirmation that job applicants cannot bring whistleblowing claims, i.e. a job applicant cannot say that they have been treated detrimentally or they've not been offered a job because they have blown the whistle. And that really clarifies quite a lot of confusion in this area about job applicants and is welcome to clearing that up. We'll see whether it's appealed, but that's an EAT decision. Moving on then to constructive dismissal. There's been 2 recent employment tribunal cases in this area, which are detailed on the slide, Walker and Hamilton. They highlight how seemingly these minor situations or minor behaviours can really escalate, leading to successful constructive dismissal claims. As we know, constructive dismissal cases and claims occur when an employee resigns as a consequence of a fundamental or repudiatory breach of contract by the employer. Now, that breach of contract can be a breach of the term, which is implied into all employment contracts, which is that the employer must not act in a way that undermines the trust and confidence in the employment relationship. And that term can be breached in a number of ways. It can be breached by one act, or it can be breached by a number of acts, which taken together and looked at as a whole undermine the trust and confidence in the relationship. And in those kinds of situations, what usually happens is the employee's treated in this way, it goes on, all these minor things, and then they resign because of what's referred to as a last straw event, i.e. the employee says, this is the last straw, I'm resigning because of it. And then the tribunal will need to look at all of the treatment that they have allegedly received, try and determine if that undermines trust and confidence, and they resigned because of it as a result of that last straw event. The employee has to have 2 years service to bring that constructive unfair dismissal claim. So the first case is the Hamilton case. In that case, Mrs. Hamilton claimed constructive unfair dismissal after resigning from her role as a diabetes specialist nurse. She alleged that her employer, an NHS trust, had failed to address the behaviour of a colleague, Mr. Nayek. She claimed the trust had not properly upheld her grievance about his behaviour and failed to implement the necessary safeguards that had been recommended in a timely fashion. Mr. Nayek's behaviour towards Mrs. Hamilton included several unpleasant actions, including ignoring morning greetings from Mrs. Hamilton, facing away from her during meetings, and stopping making tea for her while continuing to do so for other team members. Mrs. Hamilton submitted a formal grievance relating to Mr. Nayek's behaviour and how the trust dealt with this, and she appealed the initial outcome of the grievance. The appeal outcome provided 2 sets of recommendations, and the tribunal found that the trust failed to appropriately address Mr. Nayek's behaviour and did not implement the grievance appeal recommendations in a timely manner, both of which constituted, they said, a breach of the implied term of trust and confidence. As a result, the tribunal said that Mrs. Hamilton resigned because of that breach and her claim succeeded, and she was awarded £41,000 in compensation. Now, I don't know what her yearly salary was, but that compensation would have included a basic award, which is exactly the same as a statutory redundancy payment, and then a loss of earnings award, a compensatory award. So that 41,000 is going to comprise of some element of a basic award and then the rest loss of earnings that flowed from the constructive dismissal. The other case is the Walker case. He alleged constructive dismissal and direct age discrimination against his employer, an estate agency. Mr. Walker was told that he would be moving to another branch because the business had recruited someone into his role in his current branch. His replacement later left, and Mr. Walker was asked to return to the branch. Management decided Mr. Walker would share the branch manager role that he'd returned to, but they didn't discuss this with him. The other, more junior branch manager who he was sharing the post with was going to sit, and they told him to sit, at the back desk, which had symbolic and a practical significance and was where the branch manager had traditionally sat. Mr. Walker, however, was told to sit at a middle desk, which made him feel like he had been demoted. The tribunal found that Mr. Walker had been constructively dismissed due to a breach of the implied term of trust and confidence by the agency. This breach was caused by various actions, including changes to Mr. Walker's role and working conditions without proper communication, and specifically being told to sit at the middle desk upon his return to the branch, which he perceived as a demotion. The tribunal concluded that Mr. Walker had resigned in response to this breach. Although the claim for direct age discrimination was dismissed because the tribunal found no less favourable treatment on the ground of age, it found for him on the constructive unfair dismissal claim, and a separate remedy hearing is going to be arranged in respect of that. So it'll be interesting to see what compensation he's awarded if it gets to that stage. It may settle beforehand. But it's interesting, isn't it, that I think the Hamilton case, more than the Walker case, was you read it and you think, that's a bit minor. But it's interesting how all these, what would maybe be regarded as minor things, being ignored or not being made a coffee when other colleagues are being made coffees, and not implementing recommendations made at grievance levels and appeal levels in a swift manner, can lead to successful claims. Oh yes, they're my point to note. Now, this is a case I've really found interesting, and I think you will. It is factually long, I'm afraid. So I'll try and summarise it as much as I can, but the facts are pertinent to the decision. I think the case is really interesting because it concerns an autistic man. And I think that as time goes on, more people are being diagnosed with mental health conditions, more people are being diagnosed with conditions like autism, ADHD, PDA. All these conditions are being highlighted far more than they ever have been. And pupils in schools are being diagnosed with these conditions far more than they have been historically. And those pupils are going to end up in the workplace. And so I think we all need to be live to the potential traits, personalities, conditions, effects of these impairments, because I think this case really demonstrates how things can go horribly wrong. It's the case of Wright and Cardinal Newman Catholic School. And as I say, an autistic employee, he brought claims of unfair dismissal, victimisation, and disability discrimination in the tribunal. The legal background to the claim, so the legal issues that were being looked at were whether or not he had been unfairly dismissed. So for a dismissal to be fair, it has to be for one of the 5 potentially fair reasons that are listed in the Employment Rights Act. So it has to be for conduct, capability, redundancy, contravention of an enactment, or for some other substantial reason. And in addition, the employer needs to have acted reasonably in treating that reason as a sufficient reason for dismissing the employee, which includes following a fair procedure. And the tribunal will ask, was the dismissal within a reasonable range of responses of a reasonable employer. The case also concerns the legal issue of victimisation, and this occurs when a person subjects another to a detriment because they have done a protected act. And a protected act includes someone making an allegation of discrimination or providing a witness statement or acting as a witness in respect of another colleague's or ex-colleague's tribunal claim. Also, the issue of discrimination arising from disability, and this occurs when a person treats another person unfavourably because of something arising in consequence of that person's disability, and that treatment is not justified, it's not a proportionate means of achieving a legitimate aim. Usual scenarios are when an employee is dismissed because of their long-term sickness absence, which is something arising as a consequence of their disability. So they're the legal matters. The facts of the case then. Marcus Wright, he was working at Cardinal Newman Catholic School from 2005, so long-term employee. The school is a 2,500 pupil school, so it's a large school, state-funded school, and Wright became head of maths. So a position of a high potential, well, it is high responsibility in a big school. In 2014, a colleague of Wright, Sam Humber, unsuccessfully applied for a permanent post 3 times, and Wright was heavily involved in supporting him in raising grievances against the school. Humber subsequently won a victimisation claim at tribunal after Wright gave evidence in his support. So at this point, Wright has done a protected act. In December 2014, Wright was the subject of a misconduct investigation for not attending an external event and for leaving school early. He explained that on both occasions he had been unwell, and a doctor's note confirmed he had an irregular heartbeat and he was signed off sick. An occupational health report recommended a stress risk assessment. A disciplinary followed, and in March 2015, Wright received a written warning for lying to his line manager about his attendance at the event and for speaking to a colleague in a disrespectful and inappropriate manner. Time goes on, and the following year, Wright found a document in his pigeonhole. It was a 3-page extract from the school handbook on which his name was listed with a big black cross next to it. He raised a grievance in which he said the document was a deliberate and sustained attempt to undermine me due to my involvement in supporting a colleague at a tribunal hearing, which has had a detrimental impact on my health. The grievance was not upheld, so Wright appealed, which months later was dismissed. By February 2017, the school's Vice Chair of Governors had appointed an external HR consultant to investigate Wright's allegation of bullying. At about the same time, Wright requested a referral for an autism assessment because others inside and outside of work had suggested he might be. He said he needed to understand if what others thought about him was right and whether this affected his mental health. That spring, Wright had 4 meetings with the HR consultant to discuss his bullying complaints and whether these related to him supporting Humber's claim at tribunal. He also submitted a data subject access request to establish if there was any evidence that senior colleagues had taken a particular stance or attitude towards him because of his support for Humber. In June, the claimant was asked by his union rep if he wished to consider an agreement with the school to terminate his employment in return for a financial sum, a settlement agreement. Shortly after, Wright received the HR consultant's report, which the tribunal concluded was not very helpful because it did not reach any conclusions or resolve any issues. On 20th of June, Wright was asked to meet with the Chair of Governors, Tim Williamson, and during the tribunal proceedings, the tribunal concluded that by this stage Williamson had been told by the head teacher, James Kilmartin, in clear terms that the claimant had to leave, that he could not work with him anymore and did not want him employed at the school. Kilmartin, the headmaster's attitude to Wright, was summarised in a statement he provided during a later disciplinary investigation, in which he said, "Over the last 3 years, Marcus has taken up a disproportionately large amount of my time and the time of the other school leaders and governors. His repeated resort to subject access requests, grievances, and the continual, largely unspecified allegations of bullying has reduced my capacity and the capacity of other members of the senior leadership team to address the wider needs of the school and its students." Importantly, during the Employment Tribunal proceedings, the Tribunal did not think it was Wright's support of Humber that was the cause of the deterioration in the relationship, but rather his tendency to keep raising complaints, taking up senior leaders' time. The Tribunal heard that given the amount on offer in the settlement agreement, Kilmartin expected Wright to accept it at the meeting, and when he didn't, Williamson became frustrated and angry. Because Wright was not prepared to accept a settlement, he was suspended with immediate effect, pending a disciplinary investigation into whether he could continue to work at the school due to an irretrievable breakdown in relationships between Wright, Kilmartin, and the leadership team. Wright told the Tribunal, "I was devastated by the suspension, as despite my complaints, I loved my job. I was trying to get to the truth and receive some acknowledgement in order to move on. I had become fixated on the issue and therefore pursued it tenaciously, which relates to my autism." In the November 2017, Wright was formally diagnosed with autism. Subsequent grievances raised by Wright were not upheld. A disciplinary hearing relating to the breakdown in relationships was postponed, and the head teacher invited Wright to mediation, which was held in July 2018. Around the same time, the school arranged for an employment training consultant from the National Autistic Society to assess the claimant to explore adjustments for his return to work as head of maths. In September 2018, Wright met with the deputy head teacher, Claire Jarman, to discuss adjustments to the head of maths role arising from the NAS's recommendations, and Wright described the meeting as positive. However, by November 2018, Jarman had emailed Wright to propose he return to work in a different role, that of high performance coach. The Tribunal accepted that Kilmartin had told Jarman, so the head teacher had told the deputy, that Wright returning to his head of maths role was not an option, and concluded that Jarman was put in a very difficult position. The panel said it was clear that Wright had concerns about the new role, as it appeared to him to have less responsibility and was therefore a demotion. The following week, Wright's solicitors wrote to Jarman expressing concerns about the new role. In January 2019, Kilmartin wrote to Wright suggesting further mediation, but Wright raised another grievance regarding his removal from the head of maths role. The school governor, Des McCannon, wrote to Wright in April 2019 with a formal grievance outcome. This required Wright to accept the HPC role, so the high performance coach role, until he was ready to return to his normal role. The school governor wrote, "I believe that before you can come back as subject leader, mutual trust needs to be reset and built up over time. A move into the high performance coach role will allow this to happen." Wright appealed the grievance outcome. Correspondence followed, and the Tribunal heard that Wright was placed under some pressure to accept the coaching role. So Wright wrote in May 2019, saying he was willing to return to the high performance coach role at first instance in order to transition back to his permanent subject lead role, but that he would do so under protest. Further correspondence followed where Wright confirmed that he stood by his grievance appeal and that his outstanding employment tribunal claim does not go away, as I have the right to pursue this whilst employed and not to be victimised because of it. Buchanan replied a day later, while you have accepted the offer to return as high performance coach, the conditions under which you have done so indicate that this grievance is not resolved in your mind, and that it will continue to be an issue for you should you return to the school. I do not believe that this represents a satisfactory position for either you or the school. I feel that in spite of our best efforts, we have now exhausted all avenues in terms of trying to find a mutually acceptable resolution to the ongoing areas of disagreement. And Buchanan notified Wright that his employment was being terminated, ending on 31st August 2019. In December 2019, Wright was notified that his appeal was not upheld. So he brings the claim, all those claims. At the tribunal, the school tried to argue that the reason for Wright's dismissal was capability, so one of the 5 potentially fair reasons, or for some other substantial reason, which is, again, one of the potentially fair reasons, because of the breach of trust and confidence. But the tribunal concluded that the real reason the claimant was dismissed was because he would not accept the high performance coach role unconditionally. So that's what the tribunal said. The tribunal said, we believe he was dismissed because he didn't accept the coach role unconditionally. The tribunal stated that the school governors did not like the fact that Wright said he would agree to work in the new role under protest and that he would continue to pursue his employment tribunal claim. The tribunal panel concluded that this reason effectively amounted to victimisation. And the tribunal found the school's contention that Wright was dismissed on capability grounds to be without merit, as Wright could clearly do the job. The judgment continued. The tribunal rejected any suggestion that a relationship breakdown with the head teacher or the school was the cause of the dismissal. For his own reasons, the head did not want the claimant to work at the school and certainly did not want him to return to his head of maths role. The tribunal stated the respondent's case as to a breakdown in relationships was undermined by its own case and the fact that the school was in fact willing to continue to employ the claimant in the coach role. So that was stated to be by the tribunal not the real reason for the dismissal. So he succeeded in his victimisation claim and he succeeded in his unfair dismissal claim. He also succeeded in his discrimination claim, his disability discrimination claim. So with regards to that, the tribunal concluded that the reason for Wright's unfavourable treatment were his persistence in complaining and continually raising grievances, subject access requests, and the manner in which he did this. The judgment said, even to the end, the claimant announced that if he accepted the HPC role, the coach role, he would be working under protest and would continue with his tribunal claim, as of course he was entitled to do. The question for this tribunal is whether that persistence, or as pleaded by the claimant, pursuing his complaints tenaciously, and the manner in which he went about this was the reason for the claimant's treatment, and whether they arose in consequence of his autism and or other disabilities. And the panel concluded that the claimant's behaviours, which led ultimately to him being dismissed, arose out of his autism, and the treatment could not be justified. As such, the claimant succeeded in his claim of disability discrimination. So he succeeded in all his claims. What was he awarded? He was awarded £850,000. Yeah. Now, yeah, I looked at this and I thought, I know I've gone on about the facts and it is a lengthy factual scenario, but it is very difficult for an employer, I appreciate, to deal with an employee who is constantly raising grievance after grievance after grievance and just seeing no way out of trying to deal with these matters, which I think the school was in. The school had reached a point where, well, it was just, holding its hands in the air and saying, well, what do we do to resolve this? It's just going to go on and on and on and on. But despite that, because the claimant, the reason why he was raising the grievances and pursuing them was all to do with his autism, and that was the reason that he succeeded. So going forwards, employers are going to have to grapple with more of these issues, and it's going to be very difficult for them to make reasonable adjustments and to ensure that they go far enough to be able to defend these types of claims. So we are now on 3:15. I've got the AI section to finish off, Eloise. Now, do you want me to do that now, or do you want me to finish today and then we can record it at another time? It's up to everyone here whether they're wanting to sit through that as well. I think I'll probably be 10-15 minutes.
I think well, feel free to put in the chat box, everybody, if you want Keeley to continue. But what we could do is we could continue for 10-15 minutes, and then if people need to drop off because of other meetings, obviously totally understand.
Yes.
And you can just listen to the recording.
Yeah. Shall I carry on then?
Yeah, people are saying they're happy to stay.
Okay, so brilliant. As I say, it'll only be another 15 minutes, I think. So lastly then, I want to cover off AI in the workplace. This is a big buzzword at the moment. I'm hearing AI. I mean, we have been for the last 12 months or more, haven't we? More and more and more and more AI. But does anybody really know what's going on with AI? All I'm seeing at the moment is that a lot of jobs are being lost because of processes, AI processes. So there are increased redundancies because of AI intervention on sort of more administrative roles and process-driven roles. Last week, there was a case that was published called the R against London Borough of Haringey, and that involved, it was more pertinent to the legal sector, where solicitors had relied on AI generated cases which were false and hadn't ever been published. And they relied on those in arguing their cases, and it was a contempt of court hearing. Didn't decide that they had committed contempt of court, but they were heavily criticised for using AI tools without any human intervention in determining whether or not those cases were accurate. And quite right too. One of the early paragraphs in that judgment states, artificial intelligence is a tool that carries with it risks as well as opportunities. Its use must take place, therefore, with an appropriate degree of oversight and within a regulatory framework that ensures compliance with well-established professional and ethical standards if public confidence is to be maintained. As AI develops further and is used more and more, it's important that we try and keep up to ensure business protection and maintenance of standards. It's being talked about as affecting all areas of the employment journey. So recruitment, onboarding, during employment and termination. So just starting then with recruitment, what do we need to be aware of? Well, firstly, candidates are using AI, and you'll know this, Eloise, using AI to complete application forms and cover letters. It's been reported that 46% of UK applicants use AI to apply for jobs. AI may be used to answer questions asked of candidates during the application process, so pre-interview on application forms, or by job applicants to try and fill in gaps of their employment history using AI-generated plausible explanations. And those kind of matters are then very difficult for the employer to investigate, or the potential employer to investigate to determine whether or not they're truthful. Yes, Eloise.
Sorry to interrupt. I was going to say I'd also add in there people are using AI during virtual interviews.
Yeah,
So,
we'll come on to that.
Yeah. Oh,
Yeah.
sorry.
No, go ahead, because that's really interesting.
Because they can have AI up running along the same time and with their CVs, and AI will generate answers to the questions as they come in.
Oh my goodness.
I mean, if somebody's a real pro with
Yeah.
AI, most
Yeah.
people aren't.
Yeah. So, I mean, to safeguard against that, employers or potential employers of individuals are going to need to have the technology, aren't they, to ensure that they can see on screen what individuals are doing. Now, that's going to be difficult if they're using another screen. So, I mean, I think firstly, employers are going to need to reduce their reliance on pre-submitted tasks. So the old days of completing a scenario and sending it in as part of your application, I think are long gone, because we just can't determine whether or not it's the individual or AI. So it could be that you're asking candidates now to draft tasks or conduct tasks live. Everything's live, in person, preferably. If that's not going to be possible, then yes, via virtual meeting, but conducting a live task. Clearly, if a candidate has a disability, and that might be autism with associated slow processing, they might be required unreasonable adjustments to pre-prepare. And really, it's going to be very difficult to determine whether or not in that pre-preparing and being given advance warning of questions, whether they are going to be relying on AI. And therefore, what we need to do is include honesty declarations or confirmation in our offer letters. So, for example, the affirmation or the confirmation that you confirm all information and documents you provided during the recruitment process are true, complete, and not materially misleading. If any statement is later found to be false or incomplete, the company reserves the right to withdraw this offer or terminate your employment without notice and recover any losses arising. You may already have this. And whether you want specific reference to AI because you feel it's becoming more of an issue, then that should be referred to expressly. You could include a declaration that candidates are asked to complete during the recruitment process, which requires the candidate to confirm if they have used AI during the application process, and if so, how they have used the tool. We are going to have to accept that most people are many people are going to be using AI in application. So let's ask them, how did they use it? You could use an AI detector, GPT-0, to determine what extent an AI tool is being used. And you can scan it, can't you? And it comes up with determines how much of the document that's presented to you is actually generated by AI. If you do that, you'll need to include reference to using an AI detector tool in your privacy notice that you issue to candidates, so that they know that you will be using or potentially using an AI tool. And I'll come on to what also should be included in your privacy notice as well later on. So that's the 3 and 4 there in the on the slide. What then happens if we're using AI to shortlist candidates? So this again is becoming more common, particularly with bigger employers, and has been for some time actually. So employers using AI to shortlist. So not this is shortlist for interview. If employers are doing this, they will need a transparent and clear privacy notice to confirm they are using AI to shortlist candidates and potentially to detect applicants' use of AI in the application process. The privacy notice should also confirm how the individual can challenge the outcome of the shortlisting process. It should also tell the applicants their rights, including the right to request for human review if a significant decision is made using AI. And that's stipulated in the GDPR legislation. So it is made clear that if a significant decision is being made in respect of an individual using automated means like AI, then human review needs to be, there needs to be some amount of human review in respect to that process. You will also need to conduct a written impact assessment to comply with GDPR. The impact assessment shows that you have considered the risks to candidates and details how you have overcome these. And then that assessment should be stored centrally. Also, in order to ensure that you're complying with your obligations under the Equality Act, you will need to use bias testing. So the aim of the bias testing is to check that the AI tools making the decision do not impact any protected characteristic disproportionately. Bias testing is used to ensure that the AI tool you are using is not biased against one particular characteristic over another. So, for example, Amazon's system, it penalised applicants some time ago now, penalised applications that included the word women's on there. And for some reason, the effect of AI system, it taught itself that male candidates were more possible. So it resulted in the women's applications being disregarded or a higher number being disregarded. So it's important because AI tools can be wrong and they can be biased to do this bias testing. So you should do the bias testing every 6 months, depending on how often you're recruiting, and retain the scores for 3 to 6 months, which is obviously the limitation period for bringing claims. To do this, so to do the bias testing, you can anonymise a group of CVs and then obtain a selection of those with a particular characteristic. So out of those, you choose a group of all men or all women. And you then determine the success rates and compare the success rates of those with the particular protected characteristic over the others that don't have the particular protected characteristic. So, in terms of a small to medium-sized employer, this can be pretty low level. You don't have to go through every single application. It can be just a sample. And depending on the numbers involved, if you've only got, I know this is unheard of these days, but if you've only got, 20 people applying for a job, then, and you're using automated means to shortlist, you can use 5 of those to do the bias testing. But the most important factor is to keep humans in the loop. So AI should not be used in isolation when making significant decisions, and humans will need to have this input. They don't need to review every application, of course, but there need to be sufficient human involvement to review everything, and that could be done through sampling. And this involves humans reviewing a summary of the shortlisting decisions made by AI and checking for unusual patterns, or particular protected characteristics being rejected. It's important to be able to show that human oversight, human review has been conducted. What about when you're onboarding? So contracts of employment. So many people, many businesses are using AI tools to draft contracts of employment. That's great as a starting point, but you do have to be very careful because, as we all know, there has to be particular provisions in a contract of employment to ensure that you're complying with UK legislation. And an AI tool might spit out something that's relevant in the US, but not in the UK. Also, there's needs to be now specific reference to AI in some of the particular clauses that you have in your contract. So, for example, that might be the IP clause and it might be the confidentiality clauses. So, what you'll be saying in respect of an IP clause is to make it clear that the ownership of any works created by an employee using AI will vest in the employer. And in respect of a confidentiality clause, you'll be saying absolutely no confidential information or personal data should be being uploaded to an AI tool. You'll need to have that privacy notice applicable for employees, contractors and workers updated. And you'll need to include in there how employees are required to use AI in conducting their roles. You know, most people are going to be using AI in their roles, whether it's marketing to draft an article, whether it's legal to get an analysis of a particular piece of legislation. It's happening all the time. So it's important for employers to actually stipulate in their policies when an employee can use AI. And it's important to say when they can't use AI. It needs to be made clear that no confidential information or personal data must be inserted, pasted in, typed in to an AI tool. And the policy should also detail that any communication or work drafted using AI should be checked by the relevant personnel before it is sent out. Appropriate reference should be made to the disciplinary policy if the AI policy is breached. And this is going to become more and more important. During the employment then, the top risk for employers is employees pasting confidential information or personal data into an AI tool. People are still thinking that if they just copy and paste a question or a company stat that they want a view on into an AI tool, that it's confidential, that it will remain confidential. When in fact, what the tool is doing potentially is using that information and spitting it out to another user. So employees cannot copy and paste or type in any confidential information that has been obtained during their employment. It can be seen with the case of Samsung Electronics, who banned employees using ChatGPT after discovering staff had uploaded sensitive code to the AI platform, resulting in an accidental leak of sensitive confidential data. Although the severity of the leak was unclear, Samsung was concerned that data shared with the AI chatbots gets stored on the servers owned by the companies operating the service, like OpenAI, Microsoft and Google, and there's no easy way to access and delete them. The company also feared that the sensitive data shared with the likes of ChatGPT could end up being served to others. And this is because by default, ChatGPT saves a user's chat history and uses the conversations to train its models, but so that the information could then be served to other users. So in order Sorry about that, it's my dog. So in order to protect confidentiality and comply with GDPR, employers should use policies and technical controls. As we've said, the policy has to include a statement about pasting and inserting confidential information into a AI tool. And it should be stated that if you wouldn't post it on a public forum, don't post it onto AI. What are the appropriate technical controls? So they include switching off the improvement setting, which you'll find in most of these AI toolbox in the settings. So the improvement setting, so that it's not then potentially being used for and saved and reused. Also in the temporary chat, so you can actually turn on temporary chat, and that should be switched on, because otherwise it could save the chat that you are inserting. And the temporary chat is only there for a temporary period of time. Also, employees should be told to anonymise names and not use personal data, of course. So due to the mechanics of AI, employers also need to be wary of being accused of misusing other employers' information, confidential information that may be spat out to their employees when using AI, because claims could be brought against those employers for having that confidential information. Grievances and claims then. During employment, employers should be wary that grievances could be brought by employees about decisions being made about them using AI tools. Explaining decisions based on AI may be impossible due to the algorithm, and it's going to be very difficult to explain how you've made a decision if you don't understand the algorithm, which is most likely. Proposed new law will require employers to prove that their AI tools are not discriminatory, which means that the starting point will be bias, and it will be for the employer to disprove this. So that's interesting. This new law is proposing that the onus will be on the employee to actually disprove bias. Employers will also need to be live to possible harassment using AI tools. And be live to that. And then lastly, dismissals. So just be wary if you're a big employer and using algorithms or AI to select employees for redundancy, for example, which is becoming quite common or more common in big employers when they go through large scale redundancies. They have a selection criteria and then they score employees against that selection criteria. Because if you're using an AI tool to do that, then again, you've got to be careful that you don't breach the Equality Act and score somebody lower related to a protected characteristic using that AI tool. So again, human involvement in those kinds of big scale, large scale redundancies is going to be really important. And that's it. So I've finished the AI section. If anybody's got any questions on that, then obviously let me know. I appreciate I've gone well over, so apologies for that.
That's okay, Keeley. It was all really great stuff, and thank you. Fabulous as always. Do you want to take your slides?
Oh yes, I'll take
it down. Just so people can see your lovely face. Thank you so much. Yeah, if anybody's got any questions, feel free to email me or directly to Keeley. I think that AI piece is just going to get more and more complicated as technology improves. But just to close the meeting, though, thank you all for joining us. Just to remind you, for Vanilla's 20th year in business, which we are this year, We do have a special recruitment offer, where we're offering HRHuddle members 20% off their placement fee for any vacancies that are placed with us in the next few months. So just to remind you of that. Also, there are no meetings over the next couple of months for the summer. So our next meeting is on September the 3rd, and we're going to be looking at best practice for competency-based interviews. Keeley then is back with us on the 8th of October for her next employment law update. But if anything significant happens in between, obviously we will keep you posted, and we'll jump on and do a session. So also, just some exciting news. We are working on the website, but Keeley has produced a neonatal policy for the HRHuddle, which is available now to download on the Vanilla Recruitment website. So if you go to Vanilla Recruitment, there is a drop-down box at the top which says HRHuddle, and you'll be able to see the neonatal policy in there, that it's available up to a massively discounted price for HRHuddle members. So, but we'll also send out an email about that in the next week or so. So the recording will come out to you usually next week by the time I've edited it. But thank you ever so much, everybody, and I will see you soon.